All right, hello again and welcome back to the Bracewell Environmental Essentials for In-House Counsel webinar series. It's August and that means two things. It is miserably hot outside and it's time to review the Texas Environmental Law Superconference. Hi folks, my name is Daniel Pope. I am an associate at Bracewell and I am coming to you live from our Austin office. I am unaccompanied by any partners today, but don't worry. They strap these wires to me. Apparently, I'm going to get a shock if I slip up. For those unfamiliar with it, the Texas Environmental Law Superconference is a 2.5-day extravaganza where key officials, leading practitioners, and scholars all descend on Austin, Texas to discuss the latest developments in environmental law. I'm here to recap that for you, but it's difficult to condense 2.5 days of great content into 30 minutes. So if you hear something I say or see something on a slide and I don't go into it fully, please ask a question either in the webinar client or go ahead and shoot me an email at daniel.pope@bracewell.com and I'll try to follow up with you if you have any questions. Here's a brief overview of what we'll be talking about today. We're going to be looking at specifically the Safe Drinking Water Act, the Clean Water Act, some developments in the Clean Air Act, enforcement, administrative law, if we get to it. But like I said, we've got a lot to go over. I first wanted to say just thank you to everyone who was able to come to our Thursday reception. Of course, we had great food, we had great drinks, but we especially had some great music from Shiny Ribs, one of the best local bands there is. If you are looking for a music recommendation, pull them up on Spotify. Kevin Russell is a genius. He's there in the lime green suit with some people that you probably know. And y'all, it turned into a dance party. It was terrific. It was amazing. If you are thinking of making it down for the super conference at any point, please let this tip the scales. We'd love to see you. We'd love to host you at this event. And you know what else makes me want to dance? You know what else makes me want to cut a rug? The Safe Drinking Water Act. Let's get into the material. EPA's Office of Water is looking at promulgating a new lead and copper rule. It's been submitted to OMB for interagency review. And the Assistant Administrator for the Office of Water, David Ross, gave a presentation on the importance of the lead and copper rule. EPA is currently conducting a series of studies and consultations, and those began during the previous administration. David Ross indicated that they are collecting a lot of data and will be using that to drive the rule. One of the things that was pretty interesting was just how excited Assistant Administrator Ross was for the importance of the lead and copper rule as one of the greatest public health benefits to our country, really. He also spoke about PFAS. This goes by a number of different acronyms, PFOA, PFOS, PFAS. There are a number of articles you've probably read at this point talking about PFAS and where EPA is moving on this. Ross emphasized that, this is a true multimedia problem that implicates CERCLA, EPCRA, and a variety of other statutes. But the Office of Water is taking the lead on understanding the science of how these perfluorinated compounds affect our environment. They're the ones driving the bus. They've undertaken a pretty extensive scientific review of these compounds, and he indicated that preliminary results might suggest that older PFAS compounds are more toxic, modern versions less so, but like he said, those are preliminary. Let's switch over to the Clean Water Act and some important developments there. Bracewell has probably presented you with a number of different discussions about the new WOTUS rule. We've talked about that before. We've talked about it at our seminars and in other writings. As a common theme for this administration, the goal of the rulemaking is predictability, fair application, fair treatment under the statute. The WOTUS rule involved a repeal of the 2015 rule, and Ross said that the goal is that the final rule will be promulgated perhaps by the end of this year. But spoiler alert, everyone, there are going to be plenty of environmental advocacy groups challenging this new rule. It'll be interesting to see what those arguments are. There's also an interesting case before the Supreme Court regarding the discharge to waters of the United States via a groundwater hydrological connection. We've talked about this before at our seminar as well. That's actually been scheduled for November 6th, not the seminar, the oral argument before the Supreme Court, but more on the seminar later. The County of Maui versus Hawaii Wildlife Fund will be before the court, and this involved a discharge to an underground injection well in Hawaii. Wastewater's discharge to that injection well actually made it out into the ocean. According to Assistant Administrator Ross, the Office of Water does feel the need to make a rule regarding this kind of groundwater conduit issue, and it wants to respect the roles that states play in regulating groundwater in doing so. But the Office of Water is going to wait for the Supreme Court to issue its opinion. And so it's interesting to think about how that might actually play out, given how controversial the issue is. We know that the Supreme Court likes to push those opinions back to late June. We saw that with Kaiser v. Wilkie this year, a key administrative law case. And we're thinking, okay, end of summer 2020, perhaps, if the court thinks this is controversial. Well, it could not be, it may be that there's a new administration getting ready to take over before the ink dries on that opinion. So it'll be interesting to see how that plays out. All I know personally is that I would like for a majority opinion to actually be issued instead of something like Rapanos. We also had an opportunity to hear about developments in the 401 state water quality certification context. Interestingly, the existing rules for 401 water quality certifications actually predate the 72 Clean Water Act amendments. The statute, the section of the statute has been an issue in a lot of recent litigation regarding the scope of what the statute applies to, regarding a particular waiver provision. Different state environmental agencies have occasionally held that if you have amended your application for a certification, well, that starts the year over. Fortunately, EPA has actually proposed a rule just as recently as last Thursday, and the comment period for that rule is open for 60 days. It'll wrap on October 8, 2019. At the Superconference, Ross informed us that this would be happening. As with the WOTUS rule and a few other things I'll talk about, the goal is to provide certainty to the public, to industry, and to accurately interpret the statute. We will be providing you with more content down the road about what's actually in that proposed rulemaking and how it might affect you and your company. We're going to switch over to the Clean Air Act now and talk about some recent developments there. As far as new source review goes, we've seen over the past year and a half and sometimes in the past week some new developments. As far as project aggregation goes, many of you know that new source review is triggered when a physical change or a change in operation at a major stationary source results in a significant increase of emissions. Well, as with any legal question, what does significant mean? And how is change defined? Can you insert a piece of equipment into your process here? Can you do something over there and slice up your operational change or your physical change so that new source review is never triggered? In the legal world, we call this circumventing. Under President George W. Bush, EPA issued interpretive guidance that would examine and provide information on how we make decisions about what a substantial relationship is. How do we figure out if 2 or 3 different small changes or operational changes actually function as a significant change? President Obama's EPA attempted to reconsider the rule, this substantial relationship interpretive rule, but it never finalized that reconsideration. Last year, EPA concluded that reconsideration process and denied the NRDC's petition for rulemaking on the subject. It said that sources get to determine the scope of their projects. The circumvention policy, or rather the anti-circumvention policy, is really about identifying bad faith descriptions of projects that are meant to avoid NSR by undermining or obscuring the real and meaningful connections between or among a variety of changes. Project emissions accounting was also a subject at the super conference. To trigger new source review, a major stationary sources change has to result in a significant increase of emissions and a significant net increase of those emissions. The actual increase and then the significant increase or significant net increase have in the past not been evaluated at the same time. For the past couple of decades, EPA has taken the position that only increases are accounted for in the first step. You just look at the gross increase in emissions. You only consider net increases or increases and decreases in emissions at the second step for determining whether NSR applies. Because that's such a significant question for large-scale facilities and it's highly technical, EPA has developed a project emissions accounting guidance document that clarifies that net decreases can be weighed at that first step stage to see whether we have to go through this process. The benefit, if this guidance and a subsequent rule that's been proposed just recently, if this new approach to NSR project emissions accounting goes into effect, complex facilities may have more incentives for making decisions regarding emissions reduction improvements if they can make use of those emissions reductions for upcoming projects. This proposed rule was just unveiled last week. I'd encourage you to check it out. The once in, always in policy for hazardous air pollutants is no longer in effect. In 1995, EPA had issued a guidance memorandum basically saying that major sources subject to the maximum achievable control technology standards in the Clean Air Act, Section 112, if you become a major source subject to those standards, even if you make changes that cause you to drop below that major source threshold, you will still be subject to those max standards. This is the once in, always in rule. And you can see the issue there. It keeps major sources from maybe taking steps to revert to area sources by making improvements. Well, although Bill Wareham is no longer the Assistant Administrator of EPA's Office of Air and Radiation, he issued a guidance memorandum saying that once in, always in was right out as inconsistent with the statute. This memo has been challenged in court, and we're expecting a decision on it as early as fall 2019, but Administrator Wheeler has also recently signed a proposed rule that would codify what's called the Major Max to Area Source policy. There are also some updates on the Clean Power Plan and the Affordable Clean Energy Plan rule. You may have seen that just a little over a month ago, Administrator Wheeler signed that final rule. Without getting into the litigation over the Clean Power Plan, recall that it emphasized that the best system of emissions reductions for existing fossil fuel-fired power plants involves not just emissions at a site or emissions at a source and reducing those emissions, but regulatory intervention outside the fence line to shift our energy mix from coal to natural gas, and then from fossil fuel to various renewable resources like coal, or excuse me, not like coal, like wind and like solar. That, of course, was very controversial. That was stayed by the Court of Appeals in DC. And now we have a repeal and replace rule for the Clean Power Plan. The Affordable Clean Energy Plan involves a return to examining the best system of emissions reduction at a particular source. So we've gotten away from considering things outside the fence line, And without getting into the weeds on applicability, we know that this is going to apply to a lot of fossil fuel generation facilities with a particular emphasis on existing coal-fired power plants. The focus of the ACE plan is on heat rate improvements, which can include the application of new technologies or operational limitations, maintenance practices at existing facilities. The goal is to increase the efficiency of these facilities. And it's not too different from thinking in terms of miles per gallon. How much go are you getting out of that gallon or that ton of coal? States under the new ACE plan are required to submit a state plan for implementing measures and standards for affected facilities, or they can use background EPA principles or regulations. And one of the things that I've already noted is that the real focus of this administration, not just in the air context, but really EPA-wide, has been to ensure that the statute itself has been followed. A key issue with regard to ACE for the upcoming litigation season is that EPA has hung its hat on interpreting the plain text of Section 111D, which is where the best system of emissions reduction for existing power plants has been discussed. It's hung its hat on interpreting the statute. The ACE plan complies with the statute according to this EPA, and EPA hasn't really hedged its risk by making what's called a Chevron Step 2 argument. Under Chevron, if a statute is unambiguous, of course, the court is just going to interpret the statute. If it is ambiguous, then we look to see under Chevron Step 2 whether the agency has provided a reasonable or permissible interpretation of the statute. So like I said, EPA has focused all of its energy on making the Chevron Step 1 argument. The statute, Section 111D, not ambiguous, and so EPA's decision should just be reviewed for whether it complies with that statute. It will be interesting to see if courts say, actually, the statute is ambiguous, because EPA hasn't really made that Chevron Step 2 argument in its rulemaking and its preamble. We're going to move upstream now a little bit to the oil patch with BLM, and then we're going to talk about some midstream issues with FERC. Ann Navarro, a member of our practice group in DC, presented on oil and gas environmental issues at BLM and FERC in the context of NEPA and climate change. It was very well received, if I do say so myself. And she talked about what has been a problem over the past decade or so for the Bureau of Land Management, the Federal Energy Regulatory Commission. NEPA requires federal agencies to consider effects on the environment whenever it makes a major decision. And over the past decade, many agencies have struggled with how to address greenhouse gas emissions that result from permitted or approved activities. It's relatively easy to consider the emissions that might directly result from a project. Think about the emissions related to construction or annual operations or so forth. What about indirect effects, though, that can be attributed to an agency's decision? What about indirect greenhouse gas effects that could be attributed to the agency's decision? Anne discussed this in her paper submitted to the Superconference in the context first in BLM and then with FERC. The Bureau of Land Management approves leasing decisions on federal lands for a variety of natural resources, and over the past decade has had some issues with how it considers or doesn't consider greenhouse gas emissions in indirect effects analysis of its leasing decisions. This has typically been argued by various environmental advocacy groups in the context of downstream emissions. After all, these groups argue you are extracting various natural resources, coal, oil, gas, for the sole purpose of combusting those in some way. Maybe we don't know where, maybe we don't know exactly under what circumstances, but these resources are being extracted for productive energy generation of some form. In a number of court decisions, BLM has been required to consider the greenhouse gas emissions that result from the combustion of these resources. And while evaluating those emissions in highly specific ways may not always be required in these decisions, the agencies can try to reasonably forecast how natural resources will be used. For example, courts aren't expecting BLM to say that this coal lease here in Wyoming, the coal it generates or produces is most likely going to be sent to this power plant in Idaho, and it generates this amount of carbon dioxide equivalent emissions per year, right? So we don't have to get that into the weeds, but BLM is expected to at least address how these natural resources are used. Typically, BLM has not appealed these decisions. It's just gone back to the drawing board to consider these emissions, these downstream greenhouse gas indirect effects. And you can imagine why going through a lengthy appeals process to dispute whether this particular kind of indirect effect consideration is appropriate would take longer than actually going back and doing a supplemental environmental impact statement. In the context of FERC, many of you may be aware in the pipeline context of the Sable Trail decision out of the DC Circuit. There, FERC was required to consider the indirect effects of greenhouse gas emissions that were related to its approval of the Sable Trail pipeline. That pipeline was going to deliver natural gas to a known ascertainable group of power plants in Florida. As we've seen recent litigation invoking the Sable Trail decision, FERC and project proponents have tried to limit the applicability of that decision to its facts, and you can imagine why. If FERC had to consider the indirect effect of greenhouse gas emissions related to combustion of natural gas in the Sable Trail case, it was required to do so because it could identify with precision the actual sites that were going to be using that gas. But what about when a pipeline delivers natural gas to a hub? What about other contexts where it may not be so identifiable, where it may not be easy to figure out where that gas or that natural resource is going to be combusted? Project proponents have argued that in the end, Sable Trail is limited to that highly specific fact scenario. In the context of LNG terminals, the Department of Energy has been required to at least address indirect greenhouse gas emissions, but think about the context there. DOE has the export approval for LNG export activity. FERC isn't immediately required to issue that. In fact, it can't consider indirect effects of greenhouse gas emissions from downstream consumption. And Anne goes into that in her paper, and we'd be glad to talk with you more about that. In the context of the Department of Energy, it's the same problem on a massive scale. With LNG exports, that natural gas can end up anywhere in the world, and it can offset all different kinds of energy mixes in importing countries. And courts have recognized that this is a massive problem and too difficult for DOE to account for in a single environmental impact statement. And the CEQ guidance that was recently released and recently unveiled aims to help agencies figure out how to consider greenhouse gas emissions. Note that the new guidance is not primarily concerned with helping agencies figure out when they should talk about indirect greenhouse gas emissions, but rather how they should. And the first thing that the new CEQ guidance indicates is that agencies should avoid speculation. When greenhouse gas emissions downstream are significant or substantial enough to warrant quantification, agencies should try to quantify those, but the guidance indicates that it should, when practicable, try to quantify them using available data and existing greenhouse gas quantification tools. The guidance also notes that costs are not required for these NEPA analyses. And we've seen a few cases where costs have been considered, although the NEPA guidance does say that you're not required to consider costs. We have seen some issues where an agency's decision to consider costs in the form of the economic benefits of a project, right? State, local taxes, new jobs, etc. Considering those benefits can be arbitrary and capricious when the agency has not considered the economic costs or the social costs of carbon. So the cost of, in other words, of mitigating potential climate change impacts. We also heard from Jason A. Hill, the Deputy Solicitor for Energy and Minerals at Interior, about streamlining the NEPA process. At least in the Interior context, there has been a goal to improve the rate at which environmental impact statements are completed, to improve their page length, to make them, in other words, more focused. NEPA was made to foster agency decision-making. Agencies were not created to comply with NEPA, if that makes sense. And so Interior has taken steps to actually focus its own activity in this context in ways that I think will ultimately be helpful. We've got plenty more to cover. I'm just going to go over this incredibly quickly. Like I mentioned earlier, if you see something interesting here, please go ahead and email me at daniel.pope@bracewell.com, because each one of these slides has enough content for it for the previous view. Fortunately, we have some experts in Bracewell. Jason Hutt and Kevin Collins literally wrote the book, or at least a significant portion of the book, on enforcement trends under this EPA. And so we'd be glad to answer any questions you have here. The focus continues to be on worker safety. A recent corporate compliance guidance document was recently released. We'd love to talk with you about that. And that occurred in April. 3 key questions under that guidance document we'll hit real quick. When DOJ is considering or evaluating a corporate compliance program, when an offense or an allegation of offense occurs, it looks at 3 fundamental questions that the guidance goes into more detail on. First, is the corporation's compliance program well designed? Second, is the corporate compliance program being applied earnestly and in good faith? In other words, is it being effectively implemented? Third, does the corporation's compliance program actually work in practice? If you're interested in talking about those topics further, please reach out. We also received some legislative updates. Some of you may know that HB 2771 has transferred authority from the Texas Railroad Commission to the TCEQ for permitting discharges of produced water, hydrostatic test waters, gas plant effluent. This does require EPA approval. We saw a lot of flood-related bills in the Texas legislature this past session, particularly in the wake of Hurricane Harvey. We're going to have flood control planning and new mitigation funding. We're going to see the Texas Water Development Board oversee the creation and implementation of an interregional planning council for floodwaters. Kaiser v. Wilkie was a big topic at the super conference, but I think we've run out of time. We would love to help you understand that case, where our deference is currently, so please reach out there. Thank you for spending some time with us today. I hope that this was a useful overview of the super conference and seeing where some of the movement was on these different areas of law. Next month, Ann Navarro is going to be providing a review of these newly finalized Endangered Species Act regulations that just dropped yesterday. I also want to note that on November 14th, we are hosting our environmental law seminar in our Houston office. If you're listening to this webinar, you are invited. So please go ahead and mark that date on your calendar. We would love to see you there. Thanks for being with us today, and have a good Tuesday.